inviting me here today. It's an honor for me to present to you. We have a lot of very smart and bright individuals here, and I'd like to talk about something today which a lot of you are involved with the transactional part of real estate, but I want to talk about real estate through the courts, which is the topic of my presentation. Because there's many things dealing with real estate. There's so many fascinating parts about real estate. 22 years of doing real estate, and I've been doing real estate law for 22 years, and there's always something new that comes up, and especially when it comes to dealing with the courts. Something that is interesting about the courts is that there's always a surprise. No matter what it is that you do, no matter what kind of application, what kind of matter you're doing, and I've been through a lot. Through these years, I've done civil forfeiture, I've done foreclosures, I've done dealing with all kinds of things, strata disputes, nuisance, small claims, neighbors, fighting against neighbors, strata units against stratas, and all kinds of things. There's always something interesting. Now, foreclosures is something that may not be as nice to hear about. It usually means somebody's in trouble. It usually means somebody has borrowed money, used their home as collateral, and somehow something happened. Unfortunate circumstances, they're not able to, they lost their job, some health illness issues, and then they can't pay their mortgage payments. Now, one of the aspect of foreclosure I want to go through with you is not just a procedure, but maybe from the viewpoint of a lender. Many of you out there maybe have money and you want to lend to a friend. You're thinking about using their home as collateral. What are you going to do? And what are you going to do when you lend to them? And that's what I want to do. I want to go through the process as if pretend you are a lender. Now, some of these facts, some of these things I'm going to talk to you about are from actual cases. They're from cases that I've done, and also from cases that I've read and dealt with in course of dealing with the matter in the courts. So first of all, just a little bit idea about the process. Now, there's a different, it's pretty good. It's right down everywhere. So there's a few steps that everything has to go through, but as I go through this story with you, pay attention to the different points, the steps along the way of a typical foreclosure. They have very typical stages. But the first point is, the lender decides to lend money, okay? As a lender, I would look at the potential borrower. What kind of collateral do you have? Let's just pretend scenario. We have, say I have $200,000 I want to lend to somebody. I have somebody with a house and a commercial property. It's very important, the distinction between the two. So I'm going to lend $200,000. We're going to have 101. I'm going to lend maybe, but look, one property has, the potential borrower has a property that's a house that has an existing loan, which is very normal. They have a CIBC loan. Just pretend a scenario, because I'm going to get to this point where they make a default demand, and what happens? What are the challenges to the lender when it comes to making that demand? So, put this picture. You have a $200,000 house, you have another $150,000 commercial property. The house is lived in by the borrower, the commercial property is clear title, the house has a CIBC first mortgage. I lend the money, I lend $150,000, I'm thinking, hey, look, I've got two properties, I'm going to secure it, put a mortgage on the property. Fine, everything goes well, $1,000 a month, I get the payments for a year. All of a sudden, where's the payment? I don't get it. Where did it go? Are they forgot? Did he go on holiday? What happened? I would send a letter, I would say, hey, in case you have forgotten to pay your last payment, please put it in the mail. Another month goes by, another month goes by, I start to get worried. And I start to doing, hey, let's do a demand letter. For the first step, you send a letter, you have a deadline. You owe me this much, or this on behalf of the bank, you owe me this much, pay by this certain day. Deadline goes and passes. Then you have to start thinking, oh, what now? What do I have to do? What are the steps that I need to do to recover? Every day I'm losing money, every day my investment is not being returned. So you start thinking, okay, it's time to go find a lawyer. Okay, we'll start it all off. The first thing after the demand letter is a petition. You go to court. You apply to the court to see if you can get the person to come pay. Now that's just the beginning, the tip of the iceberg. In the petition, you would name things such as how much is owed, you want to get the whole entire debt back, you want to say that the borrower defaulted, you want to get a judgment saying that the borrower defaulted. They did not pay, and it's pretty hard not to prove that a person did not pay. So, and then you have to serve it on the person. You have to serve it on the borrower. Now, this point is a tricky point for a lot of lenders. Where is the borrower? Where do they go? Are they home? Knock on the door, the blinds shut, doors closed, they're trying to evade being served. You have to serve it. So that's the first challenge, you serve it on the borrower. As soon as they serve it though, you successfully serve the notice that starts the whole foreclosure proceeding on the person, they have 21 days to give a reply. I agree, disagreed, I don't owe that much, I paid, what happened to my money, who knows. But after that petition, the thing that I would do as a lawyer, someone who's owed money, I would put a lien on the properties that are on stake, which is standing for CPL, which is a certificate of pending litigation. So anyone who wants to potentially buy, they will know that there's a lien on the property. It says this house is tied up, somebody owes money to this, better not buy. So this is a protection for the person who's lending the money. Put the lien on the title, have a petition, it's served. The next thing you do is go to court. Now the first step of that is the first court hearing proceeding is called the order nisi. The order. I got this thing from Amazon yesterday. Oh shoot. Alright. Okay, hold on. Okay, never mind. I won't do that again. Just go forward and back, that's it. I'm not gonna do anything else. So the next thing is you go to the hearing. It's called the order nisi hearing. Now that hearing is where the lender wants to get a judgment, a declaration that the person who owes money actually owes them money, that they actually did a default. But one of the biggest part about this part is there's a time set for the borrower to pay back the money. It's called a redemption period. Now the redemption period is normally, does anybody know what a normal, ordinary redemption period, how much time is a borrower allowed to have in order to pay out everything they owe to the mortgage? Does anyone know?
30 days.
30 or 90, it's like a bid. Who gets the highest bid, you get the bid. Sorry.
6 months.
6 months. It's very, it doesn't say that in any law. It says of no statute. But 6 months have been a time frame that's been developed through case after case after case. And it's very, very, very difficult if you want to have anything less than 6 months. As a lender, you want, hey, I want to get my money as fast as I can. Every day is ticking, money's going out the window, I need the money, what's happening? 6 months. You have to be really hard pressed to convince a judge at the order nisi hearing to get anything less than 6 months. Now, does anybody, this pretty good guess there, get this into participatory mode. Does anybody think, or can anybody suggest, what are the kinds of things that goes into the judge's mind when it comes to thinking, how long do they need to get a redemption period of time? What are the factors? Darn, I think I missed it here. Where is it? Oh, man. Okay, it's somewhere in my PowerPoint. I just can't find it now. Did it? Fourth? Did I see it?
No, the first.
Ah, right there. Actually, it didn't fit my screen. Maybe the other screen shows. I don't know. There. Good. Okay, I'm going to go back. Now, those were the answers. Does anyone have some suggestions about what are important factors that a judge would think when it comes to giving less time to the person who needs to pay up, or more time for the person to pay up? Anybody have that idea? Suggestions? There's 3 right answers, but every other answer is perfectly fine.
Hire the right lawyer.
I like that one. You just hire the right lawyer. That's good. Actually, you know, is Richie here?
Yeah.
I didn't see him before. Anyways, I'm gonna mention him, but I'll wait till he comes in and I'll mention him. But anyways, but the right lawyer is me. No, I'm just joking. So anyways, besides that, one of the most important, there are 3 the most important reasons. One is say for example, every month you have $1,000 you have to pay in the terms of the mortgage. How much equity is there in the house if you take away the mortgage? That's one of the most important things. In a 6 month period of time, would the equity deteriorate so much that there's nothing left enough to pay back the bank? One of the most important things. But, you know, there's other things. besides equity. One is if there is something happening on the property that if you don't take immediate action, something's going to happen to the collateral. For example, if there's mold on the property, there's neglect, nobody's taking care of it. There's this, as you let mold fester, and there's going to be more problem. If there's a leaking oil tank, things are leaking into the ground, and it's causing more damage. So if there is increasing daily risk to that security, that's another reason for a short period. Another one. Anyone? Any more guesses? Okay, let's just pretend, and this is actual fact case scenario. So in one time situation, I had a foreclosure proceeding, I'm all ready to go, I'm at the order and I hearing, and it happened to be December 23rd.
A holiday.
Your Honor, I want to take this house, I want a one-day redemption period. And then, guess what? The borrower brings a big lawyer down from downtown. Where are you, Richie? Are you? Stand up, where are you? No? Any other lawyers here in this room? Oh yeah, there. I don't know. Anyways, he shows up with his client, the borrower, says, Your Honor, he can't do that. It's Christmas. There's a family living in this house. You can't do that. There's a family, there's a husband, there's a wife, there's a grandmother who lives in the house on the tree, and there's presents. There's no presents under the table, Your Honor. Oh, you know what? I'm trying to chase after this potential borrower for a long time. I give all kinds of leeways on behalf of the client, but so you come across these things. If a property is lived in by a family, you're hard pressed to get something quicker. You give them time. The rule, the law, is to help the person, prevent them from losing something that they've invested all their time or effort or savings with, and effort and time. So you have a family, it's hard. If it's abandoned, if it's empty, then you have a different issue, right? So I just put a little list over there, the questions to ask. Are the property taxes? Oh, that's an interesting one, because the city can come in and say, hey, you owe taxes, we're going to take your house and we don't care how much you owe the bank. So the more taxes are owed, the more that is imminent that the city may foreclose on the property, the faster it is that the courts may even allow an exemption to have a faster redemption period. So that you can, in the eyes of the lender, you're risking. The more you wait, the more you might lose any chance of getting anything back. So sufficient equity, is it single, is it tenanted, is there waste, is it abandoned, is there a decreasing risk of losing your equity as the time goes by? These are all issues that affect redemption period. There's an interesting case, safety first savings. I'm not going to pick on any bank, but anyway, this is a good case if you ever had a chance. Ask any lawyer, they like to read cases all the time, kind of weird that way, but it's good. If you have a chance to look at it, it's interesting. So it has all those issues about how a redemption period can be increased or decreased, and those are important challenges if you're acting on behalf of a lender. Now, acting on behalf of the borrower, there's other things that, exactly like I mentioned, you bring all these issues up to make it 6 months, to prevent it from being shortened so that there's more time. But what can the buyer do, what can the borrower do to take care of this? Before I do that, the previous case, where was it? This one. Actually, it's very interesting because the borrower went bankrupt. Now, one of the biggest things to argue, like, Your Honor, he's bankrupt. What are the chances that this guy who's bankrupt can actually get another mortgage and refinance and pay out the existing first mortgage or the second mortgage? Pretty unlikely if it became bankrupt. They're unlikely. So that argument that's tried and used and still rejected because the courts still say there's 6 months in which they can sell the house, not just refinance the house. So give them that time to do that. So these are all different factors, right? So you start from, let me go backward a bit here. That case is interesting. So let's just say this, 6 months have passed. We've gone past 6 months. We give the borrower, the time to come up with their own funds, get another bank, find another friend or family to come up with money to pay. They can't. After 6 months, then what time? What happens next? So the next is a difficult choice as well for the lender. You have to choose, and the choice is between two things. Now, you get an order of absolute, or you get conduct of sale. Now, what is the difference between the two? Anybody? Sorry, I flashed that so you can read it, but anyone have an answer? What is the difference between the pros and cons of either getting an order of conduct of sale or an order absolute? Any guess? So any of you who are thinking of lending, and these are issues that come up, but they're really interesting stuff. So the first thing is I want to talk about is conduct of sale. Now that is the most preferred method for any lender in a foreclosure area in a situation to decide what to do after the redemption period is over. What's good about conduct of sale? What is it? Well, the court orders at the next hearing after the order by hearing, the court orders the lender to have conduct of sale. Means they can now have the right to list the property, to find a realtor, to get an appraisal, and then start listing and selling the property. Looking for a buyer, looking for enough from a buyer, negotiate from a potential buyer to have enough in order to pay off what is owed to the bank. Now what's important about conduct of sale versus an order absolute, one of the biggest thing is, sorry, just to tease you again, before I go that, is one, order absolute as opposed to conduct of sale. Order absolute is like giving the house, transferring it completely to the lender. It is now the lender's. But in order to do the transfer, the lender has to pay PTT. They're just like any buyer. It doesn't matter if it's residential, if institutional lender or lenders, they're not living in this house, they have to pay property transfer tax. Another thing, which is pretty big too, is any shortfall is absorbed by the lender. So it's different than conduct of sale. If they sell the property using that other way of doing it, right? They got a conduct of sale, they listed it, they sold the house, there's a shortfall. If there's a shortfall, the lender can still go after the borrower for the rest of the remaining funds. The opposite is getting order absolute. You get the house, you get the title, you pay the property tax. If you have a loss, you cannot do anything more about it. You've closed all your options to get anything left over if there's a deficit. So conduct of sale is the property. One of the things about sale of properties when a lender has conduct of sale is normally it's going to be sold as is. The lender has never lived in it, they're not going to make any representations. You, as all the realtors out there, if you're listing a property that's for foreclosure and you're helping out, you want to make sure there's no representations, no warranties. The person who buys as is. And subject to court approval, that's very important. Now, that's also a risk. So, another challenge from a lender's perspective. So you get to the court, you got the contract, you got enough money, oh, it's great, looks good, looks like there's enough to cover what I have to owe. Then you go to court, you have to present to the court. The court, at that point in time, doesn't have to just accept your offer. Other people are open to put in a bid, another offer. I think it's anytime that there's a property for sale, on the listings, there's this way to find out whether it's a court-ordered sale, is it a transfer from a state or something like that. So then people are open to put in a bid. You go to that next hearing date, where it's the point of time, the court hearing, where the court can order a sale of a house based along the foreclosure sale. But other people can put a bid in. So I go to the court and we're ready to go. I got my offer. And the bank, the lender, me or the lender, had hired John here, John Ying from Joby. He got an amazing deal, $100,000 over asking price. Amazing. And then, as I'm sitting there thinking, I've got this, guess what? Someone else pops up in the court. Let me see. He's Lo Ming. Hey, Lo Ming shows up, and he's got an offer in a sealed envelope. I don't know how much it is, but it could be outbid mine. Oh my God, look, it's Eva. She comes in too with another deal. Another envelope. No idea how much is inside. And it all goes to the judge. The judge opens up the envelopes and say, hey, Ken, do you have an offer too? Come on, Ken, bring it up too. So, everybody. Now, it's an open bid. Like, the judge has to make the decision. So, that's why you have to say subject to court approval when you do these sales, because you don't know. You may think you got a good deal, then a better price comes in, but you may not even know. You don't know. You open it up and you will see. Because one of the things is that the listing price is available to be seen. You know that it's a foreclosure sale. You know that there's a listing price. How much do you bid? It's not a point of negotiation anymore. You can't do back and forth. There's nobody to do that with. You either offer a deal, this is the price, get it or you don't get it. You get everything as is, or you don't get nothing at all. So this is one of the risks. You go up in court, you still don't have it, and then the judge opens up the envelopes and says, and the winner is, huh?
Your teeth.
Oh, tea. I get tea. Oh, thank you. And the winner is John, because his bid was $100,000 more than anybody else's, and then you win. But this is the thing, is that there's a risk, and there's challenges all along the way. You know what? Another challenge can come up once you did that. Not only is it the price, the owner, the borrower can still show up in court. Says, Your Honor, the marketing people at Joby, they did such a good job in Vancouver, but they never marketed in Richmond, where more richer people live. Right? Then you go, oh darn, the judge will think, oh man, maybe I should make this process last out a little longer. Maybe the process of advertising is not as good as it should be. You have a good lawyer out there who's representing the buyer, you start the borrower, sorry. And then you come up with better ideas of how to get back the house. So, as it's important to do is hire a good lawyer, no matter which step of the way. Either you're doing a bid, you're representing the lender, you're representing the owner of the house, the borrower who's about to lose their house. Do whatever it takes in order to get the house back. Okay? So you get to this, and you get to this point. You got the conduct of sale, you got the offer, you got the one, you've won the deal. And what happens at the end of this process is that there is a completion date, just like any other purchase and sales. There's a completion date. Instead of a Form A transfer being registered to the land title office, it's the order for sale that had been approved by the court, which indicates who the buyers are, what the price was, and what was the winning bid, and all the terms on that as well. So that's kind of like the process. You go from beginning, from as a lender's perspective, coming in, wanting to foreclose on the house, and get to the point where a deal is accepted, and the buyer becomes the new owner, and the amount of money may or may not be enough to cover what is owed on the mortgage. Now, one of the things that I wanted to, the concept is important as well, is that during the time from the order 9 side, so let's go back a bit, 1, 2, 3, 4, yeah. So from the time of the order 9 side to the order absolute, the interest that the lender is getting is no longer what was in the mortgage that was signed at the beginning. This is court-ordered interest. So usually in that situation, it's a lot less than what the original contract for the mortgage was as well. So that's one more thing that the lender has to be aware of. As soon as you get the order until the sale is done, or the contract of sale has been given and the home is sold, the amount of accumulated debt in the mortgage is, during that period of time, the interest is not the same thing as what was in the mortgage that was signed up. Extended, so let's move on. Oh, interesting, priorities. Remember that the scenario I told you about, the house had a CIBC mortgage and a first mortgage. So me as a lender, I'm not an institutional lender, I'm not HSBC, just pretend I'm one of the lenders, but I'm a personal lender. I'm a friend, I have some extra cash lying around, I thought I'm gonna help a friend, lend the money over. I'm not an institution, I'm not a bank, I don't have vaults full of cash. The money that I lent, that was all I had. So the thing about this is that if you had a first lender, CIBC in that house, they may also challenge you having conduct of sale. So instead of the people coming out with their lawyers and trying to find the borrower comes up to the lawyer trying to take back their house and giving reasons why it wasn't marketed correctly, you have a lawyer, or you have an offers coming in that might outbid you as well. You may even have this challenge as well. So some of the rules when it comes to who has priority is important, because if I was not an institutional lender, I cannot do what sometimes is done. Institutional lenders can buy out the mortgage debt of the first one and take over that place and be the one that has the conduct of sale. They're in charge now. But in most situations where it is not an institutional lender, they don't get that chance. Here it is. Here we go. So when it comes to that house, the CIBC lawyer comes in and says, hey, I want conduct of sale. And I say, hey, I'm not institutional, give it to me. And then normally the conduct of sale is given to that lender. Now another thing too is based on how much is owed in first and second. So the idea, the concept is a lender who's registered second on title has more to lose and more to gain by getting the highest price possible, because they want to get enough to cover the first and the second, more motivated to get a higher price. Sometimes that's the reason why contract of sale is given to the second registered lender as opposed to the first. Depends on who is more motivated then to go after and get enough money for to pay off everybody, not just the first or second lender. I mentioned this before, like if you were the borrower, like what can you do? You can sell the home, try to find a buyer, try to get another lender who can pay out the first and move on. You switch basically one lender to the other. One more thing to add in terms of the cost and money is that not only is the mortgage amounts due, but also the legal costs of the lender. The cost to find and search and serve and start the court proceedings and go into court every day. There's court and legal fees added on top of whatever the court ordered interest was, on top of whatever the mortgage interest was accumulated up until the point of the order 95. Okay, I think that's it. Oh, I got this thing here too, because if you want to find out if property is court order sale, I got this actually. I didn't know about this. I know it exists somewhere. My friend Pedro, where's Pedro? Pedro, straight hand. Yeah, he said, hey Pedro, can you give me one of these? And he sent this over to me, and I put on my PowerPoint. It's pretty good, pretty fast. Okay, I'm good. Now the second, I'll probably ask questions later. I want to get through this. I got, how much more time do I have left? 15. So the second thing I want to talk about today is probates. Probates, land transfers through wills, those kinds of issues. This is another interesting and fascinating aspect of land transfers that happens through the courts, basically, because before something can be sold, a property can be sold if it's in the property that belongs to an estate of someone had passed away, that has to go through a potentially long, arduous procedure before you can actually sell and buy a house. So the next one is about probates. Now, there's a couple of things about this which is important. Let me see, click. Good. No, I don't want to go to timelines just yet. Actually, this thing cuts off a lot, I think. No? I think there's things at the bottom. Oh, never mind. There's different items here. But anyways, one of the most important things about the states selling a house is that there has to be a court process. A court process to determine, I got a remote control over there. Hold on. So anyway, there has to be a court process that happens. Just like I just described the whole thing about probate, foreclosures is a court process. In going through the courts to distribute a house that's held under a state, there's a process called a probate. It's the process of the courts proving that a will is valid, or if the person died without a will, that all efforts have been done to search to find whether a will exists, and if none exists, then it proceeds as if it has no will. So there has to be a process first. You have to prove to the court to find out whether there's a will that exists, and then A, who is the executor, and B, if there's no will, then someone has to step up and make that application to the court to become the administrator, to first get the ball rolling and call that process. And this is part of the same process. The person either finds the will and then starts the process, or the person searches everywhere, including searching vital statistics for any wills notice searches. None. Okay. Next step. Then you have to start looking for all the properties that the person who had passed away owned. You search, you look, you find, you evaluate, you find how much it is. Then you put it all in several affidavits that all get filed into court. Now, one of the important things, and this is the biggest challenge when it comes to this process, is that the notice has to be given to all potential beneficiaries who can inherit either through the will, or if the person died without a will, all potential persons who could potentially challenge the way that the house is going to be distributed. I'm saying house because this is real estate, and it could be other properties too, but I'm talking mostly about houses. So, sorry, this is a little forward. I meant to go back a bit. Hold on, there we go. Okay, well, I'm not quite there yet. Just want to go through some processes first before we get there. So the notice has been given to all the potential beneficiaries. Now, potential or beneficiaries are those that have a right to inherit. Okay, these are the potential groups of people that can challenge the whole process. So, May, tell me how much time we have? I can rush through this. We're good? We're good. So, the idea is that, does anybody want to, I know some of you know for sure, but just a hand, who can tell me who are entitled to challenge through a will or an estate?
Anybody.
Oh, good one. One answer is anybody. Well, you know what? Anyone can challenge. The idea is whether they're going to win or not is another question.
Yes.
It's based on evidence and proof. So besides the fact that anyone with a crafty lawyer can find an argue a novel excuse, actually, if someone would, I have a whole episode on YouTube. It's a podcast from my CHMB episode dealing with 9 different ways to bury a will. So if you can search it up on YouTube, you can find it. But it's all in Cantonese. So yeah, there are many different ways, and you can find all kinds of ways. But legally entitled, people who are entitled to. You have a guess? I'm sorry, your name? Victor. Hi, Victor. Yes. Immediate family. That's close. That's 80%. That's like a B+ answer right there. But part of the immediate family doesn't include brothers and sisters. So immediate family, according to WESA, the Wills, Estates, Succession Act, is spouse, could be common law spouse. So someone in your marriage-like relationship for 2 years or more, and married spouses. Second, how about anybody want to think stepchildren? Stepchildren, are they?
Yes.
Want to say yes or no?
Yes.
I hear yes, yes.
Definitely.
Stepchildren?
Yes.
The answer is no. No. Stepchildren are not legally entitled to benefit under a deceased person as well. Now, they have to have a formal legal process called an adoption, legally adopted before they are entitled to make that. Now, of course, they can always try. They can always use other reasons to challenge. They can't use the Wills, Estates, Succession Act to challenge, but they can use other things, such as, the idea of trust. Anybody heard of trust?
Yep.
There's another way. So someone who's registered on property, but someone else is the real owner. And there's many of those type of situations. They can bring it up and by saying, hey, I lent all the money, but I couldn't get a mortgage, and therefore the other person was entitled. But really it's mine. These kinds of things happen all the time, but they are not under the Wills, Estates, Succession Act to make those claims. Could be spouses that are not registered on title. It could be, I heard the word mistress. Actually, that's very, I had this one situation where the same thing happened, and it was held, not joint tenancy, but tenancy in common for some weird reason. So all of a sudden I was helping administer the estate for this lady who then became the owner of a house owned by the other half, which is owned by the mistress, which, whoa, don't want to go there. That was, oh boy, anyways, a lot of fireworks there. But anyways, yes, that can exactly happen. So you have all kinds of things come up that may prolong the whole entire process. So what you started off with, hey, 3-4 months, get through the assets, file it in court, wait for the court order, pay your probate fees. Oh, by the way, anyone know how much probate fees are?
Yes.
The highest bid, higher bid? No.
2%.
Not the PTT, not the property transfer tax.
And then 2% amount.
Probate fees. It's based on the whole entire value of the person's estate, not just the house. Put it all together, you have an affidavit with a number. So, basically in general, it's like a 1.4% of the whole entire value of the estate. So, but the idea is that there's a whole process involved. It can take a long time to find, to work, and since you get all the things together, you do the affidavit, you send the notices out, then people start challenging all over the place, maybe, possibly. So when you put in a sale and you have a contract and you're selling a house that's being someone who had passed away, you might want to consider that it may be a little while. On average, normally when I do probates, I check out which registry is working on their paperwork and which one's faster, then I'll file it at the faster court. 3 months? Okay, file it. 6 months? Sorry. And it changes. Sometimes it gets busy, sometimes they're not busy, so it takes time. So all the time, whatever you do, when you are in the process of selling a property that is, in this kind of situation, you have to have it subject to the grant of probate. You don't know when that's going to happen, but on average it takes 3 to 6 months, so you have an idea. Now, one of the things about this is like, okay, so you passed through all the challenges. You got the grant, nobody challenged it yet. Okay, you got to the point where now you got it. Now then what do you have to do? So there's a couple more timelines that are important to know about. One is the first one. Grant of probate from time of filing, on average 6 months, that's the first thing. But the transfer of the property, 210 days. Now what this is that before the property can be transferred to the beneficiaries under the will, there have to be a waiting period. Now there's a further waiting period for challenges to occur. So you have 210 days for the grant of probate. You get the grant of probate doesn't mean you're automatically allowed to do anything you want with it, because there could be challenges still. But this time frame is for transferring to the beneficiaries. Now before this happens, of course, the transfer has to happen. The grant of probate comes and issues and appoints and authorizes someone, namely the executor or administrator, to have the power to administer the estate. So the first transfer that happens is a transfer from the estate to the executor or the administrator. Now, then the administrator has the choice, usually following under the will, what to do with this property. If it is to divide it amongst the beneficiaries, there's a couple of choices to be made. You have to follow the will. Does the will say the person who is the executor, do they have the power to sell? Do they have the power to add people on title? What powers does the executor have? So you might want to check the will to see what it is they can or cannot do. So say they can, okay, they're able to sell, but they can't give it to the beneficiaries. They can sell and distribute the money, that's one thing, to the beneficiaries, but they can't transfer to the beneficiaries until the time has elapsed. And then unless everybody who is potentially eligible to benefit, they have signed a consent. Okay. So another time frame? Oh shoot, I think it was actually at the bottom. Where did it go? Oh, Jesus. Okay, sorry, 1 second. There's another time frame. Is that 6 months after the grant of probate? Let me try one more time. 2. No, there's another one that I'm sure is at the bottom here. But anyway. Okay. But it's 180 days for the grant of probate for any challenges to be filed in court. And if there is a challenge, it has to be filed within that 180 days and served within a month after that. So there's a time frame to wait. So if I was, I have a question to this point there. It's probably answered with it underneath this, but you can't see it.
Since we have such a division, what should a realtor write down today regarding a complete sale?
Yeah, so the question about is, what should you say? Because all these things could happen. What are you going to do? You want to cover your, what? So straight down, well, where is it? Where did it go? Oh, man, okay, you know what? I thought I had it down. Anyways, my son taught me PowerPoint, and I never used PowerPoint, so I'm still trying to figure it out. But anyways, so the question is, what should we put down? So first of all, you have an idea. The first thing to do is, if there's any way possible, try to sell the property that's been already transferred to the executor of the state. The title says this. Do I have the title search here? There. The title says this. You check the title, it says who is what. It's already registered. Executor of the will of such and such, deceased, so and so. You see that on title? Oh, sorry, you're taking a picture. Here, get back here. So you see it. Then you know, okay, good. Then you look at the time. When did it happen? 2019, 10, 17. So then you have to start calculating, how much time has passed? Is it safe? Is it ready to go? Right? So sometimes when you want to be absolutely clear, wait for the time frame for anybody to challenge. 180 days after the grant of probate, when you're still looking at that. Oh, what happened? Okay, there we go. So 180 days after, 1 month for someone to file and serve it on the person. So at least 7 months, please. 180 plus 30, 210 days. Yeah, 210 days, wait, if you can. If you absolutely can't, okay, if you don't get that deal, you don't get a contract signed, and it might go away, then you want to have subject to, right? Subject to what? Subject to all the people who could potentially challenge the will being cleared and passing the deadline to do so. So you pass the deadline after 7 months, so you have that statutory time frame that you can put right on the contract. subject to, I have it written down here. I'm sorry, I wrote it down. Close to, oh, there we go. Suggestion, clause to automatically extend the subject removal date, clause to automatically extend the completion date as well, for example, 15 days after the grant of probate, if you're before you get to that point. Subject to the seller receiving the following by a certain date, a copy of the grant of probate, and this is the big key here, because this is the assurance. You can get that grant, but you can still have a claim. So assurance that everyone entitled to claim under the Wills, Estate and Succession Act has waived or released their claims against this property. This condition is for the sole benefit of the seller. So you have that, and then that's what you write down. Now, in terms of the timing and date, that's where you have to find out. You search, you look at the grant of probate, see when it was done, and look at the maybe even better. Hey, consult with a lawyer. What does the will say? What are the potential challenges? Is it safe or is it not safe? Okay. So my time is up. Thank you, everybody.